Hello everybody, welcome. Today we're going to talk about an EB-2 NIW, so National Interest Waiver case. So this case was filed in the U.S. District Court for the District of Columbia, and as you've seen, a lot of the mandamus cases are filed in the District of Columbia. Very rarely you see them filed outside of District of Columbia, and we have seen a few that were filed outside of District of Columbia. So here is the plaintiff, and there's quite a few defendants that were listed. So this is a petition for the writ of mandamus for the APA declaratory judgment and injunctive relief. And so let's take a look. So this is the petition for the writ of mandamus, and they're looking for a complaint of judicial review, declaratory and injunctive relief. So this is regarding a decision denying a motion to reopen and I-140 NIW National Interest Waiver petition. So basically, the National Interest Waiver was denied, and they had filed an appeal, and this mandamus is looking for a decision on that. So just an introduction on this is the USCIS decision denying motion to reopen I-140 NIW National Interest Waiver petition. As of date of this filing, plaintiff's appeal has been pending for over 9 months without an indication as to when the Administrative Appeals Office, so that's what this is, the AAO Administrative Appeals Office, will schedule plaintiff for the required hearing and adjudicate his appeal. So they listed quite a few defendants here. Then it is common in the mandamus lawsuits that to do that. And then they're saying that there's an unreasonably delay in acting on the appeal, and they're asking for the court to compel the defendants to act on plaintiff's appeal within 30 days, and they're asking the court to issue a writ of mandamus, and they're saying the court has subject matter jurisdiction over the claims that's alleged, and then they're saying the plaintiff has exhausted all remedies. So just look at the party. So the plaintiff, I guess he resides in Chile. He filed the National Interest Waiver, I-140, and they're listing all these defendants. And like I said, it is common in an immigration mandamus to list all this defendants. And the statement of facts, he's national of the Republic of Chile and the Kingdom of Spain. I have never heard of Spain being referred to the Kingdom of Spain. I guess that must be common. Kingdom of Spain and Chile. And it says that he filed an I-140 petition for the EB-2 NIW for members of the profession holding an advanced degree seeking a national interest waiver. And then they're saying that in May 2023, USCIS issued a RFE, a request for evidence, regarding that petition. And then July, the plaintiff responded to the RFE and submitted additional evidence to support his petition. And then in August of 2023, USCIS denied plaintiff's petition. I mean, it's pretty common for national interest waivers to be denied. I think the approval rate has been going down. In September 2023, plaintiff submitted a motion to reopen to USCIS to overcome the grounds for denial. And then they're saying that in May of 2024, without considering any additional evidence of the record, USCIS denied plaintiff's motion to reopen, and then he filed an appeal to the USCIS decision to the AAO. And so now that's what this mandamus is really about, right? So it's really about the he hasn't heard anything regarding the appeal to AAO. He's asking them to make a decision on that too. To date, AAO has taken no action on the appeal. Then they're saying that between September and March, the plaintiff's attorney repeatedly contacted USCIS to request an update on the plaintiff's appeal, and there had not been any responses. He exhausted all his administrative remedies. And then here's the claims for release. So they're talking about APA in violation of the defendants. and then they're also looking for just a quick background. I think this explains the plaintiff's EB-2 National Interest Waiver petition seeks a waiver of the labor certification. Anybody that comes here, for employment based, you need a labor certification, right? So they're seeking a waiver of the labor certification process based on they're saying substantial merit and national importance of the proposed endeavor. This waiver reflects a recognition that petitioner's contribution would benefit the U.S. by making the traditional labor certification process unnecessary. Okay, and then the count 2 is the mandamus, and they're looking for relief from the court. So so thanks for listening for regarding this case. If you like this, subscribe, give me a thumbs up, and look forward to the next case. Thank you very much. Bye bye.